the idea of limited liability and the corporate veil. It's the sort of thing that is fundamental to company law. So hopefully everybody comes out of these classes with an understanding and appreciation of the purpose and function of limited liability. These two cases, for instance, VTB and Prest, that are both from 2013, and they again try to understand and interpret the meaning of limited liability and its consequences. How come something that is settled back in the 19th century keeps coming back to us now and people are still arguing? It probably suggests that it is not as settled as we think. The overarching theme in all of this discussion is the idea that the shareholders of the company are protected by limited liability. Agents of the company, the decision makers, when the decision makers do stuff that are wrong, then the company gets in trouble. Maybe they themselves get in trouble. Directors themselves can personally get in trouble for doing stuff wrong, both in a civil and criminal sense. The people who run the show is not the people behind it. The people behind it are the owners of the company. They're the shareholders. These guys, if we're talking about a limited liability company, are protected by what we call the veil of incorporation. So there's the stuff that the company does here, and then there's a curtain, and behind the curtain is the shareholders going, we don't care, nothing's going to happen to us. Coming back to the idea of lifting the corporate veil. What if you know that the company is nasty? Why would they do nasty? They're nasty people. Or it could be that they think maximizes value for their shareholders. It could be that they're not naturally in consequences for people around them, but they're just thinking, we save money by doing it this way, and if we're saving money, the cash flow for our shareholders, which is great. So then our shareholders get more money, they're happy, everybody's happy. They can remove the directors, so you could lose your job as a manager if the shareholders are not happy, so you do have an interest in keeping them sweet. What if, in an attempt to protect yourself, you try to game a little bit all this stuff about limited liability? What happens if you have a subsidiary, it's a big multinational corporation, and you've got a subsidiary somewhere that is engaging in something dangerous that could generate some liability. And what you're trying to do is you're trying to take advantage of the idea of incorporating separately in different places and protecting your shareholders from any resulting liability. Subsidiary that is nasty, asbestos, right? You know what asbestos is? It's a dangerous chemical. It used to be used for fireproofing because it doesn't burn, which is if you live in a block of flats. And they were using this a lot since the 1950s, 60s, it was all over the place. Problem with asbestos is that it causes cancer. It's highly bad for you. So you cannot inhale it. You have a multinational that's got a mining operation in South Africa that's generating the asbestos. They've got an American subsidiary that is using this asbestos to put in buildings and all of that stuff for insulation. It turns out that a lot of the workers that were working in the American bit of the company, they got sick because of the material. The company kind of knew that asbestos is not good for you at the time that these people got sick. The American workers, they sued the company in the States saying, dude, you had us working all these years without protective equipment and all that stuff, and now we've all got cancer, so now you have to compensate us for the effects on our health. The company goes, no, we didn't. No, we don't care. They take them to court. The company loses. The court says, well, you knew that this is bad. These people have suffered the consequences. It's your fault. It's your negligence. Therefore, you need to compensate them. The American company goes, fine. Look in their pockets. Whoa, we don't have any money. Where's all the money? Well, all the money has gone back to our shareholder. Our shareholder is the British company here. The Americans go, oh, right, okay then. So you guys are all in on it. Because you got the parent company sitting there in London really nicely, tall hats and umbrellas and all that stuff. The bad stuff is getting sucked out of South Africa, sent to the States where it's poisoning people, but all the money gets sucked back into the American parent who's the shareholder. So we're going to come after you guys. So they come and they begin their actions here in London. The case comes in the form of, it's gone through a lot of courts and a lot of things, but the relevant one for us, Adams versus Cape Industries, right? It's a case from the 1990s. It comes up to that court, and the court has to examine the extent to which limited liability can help to protect people that are engaging in nasty stuff in these circumstances. So the claimants, they go and say, look, this isn't right. This guy's economic unit, it is a multinational corporation integrated. So what it does is dig stuff up one end, sell that stuff the other end, move the money, shift around from here to there to kind of maximize various tax efficiencies and kind of hide the other limited liability. But for what it's worth, for everybody else, this is one company that does one thing across the planet. So it does sound a little bit terrible if you allow them to hide the money here, the liability is generated in another jurisdiction, but all the money is sitting here, and when the people come and claim, you go, oh, sorry, these bits over there don't have any money. So even though you guys are right and you guys won the case, you're not going to get anything. All the money sitting here with the shareholders. So one argument is that this economic unit. The second argument is that this is a scam. This is one of these transfer scams where you leave your nasty operations at one end and you have your money hidden in the other end, and you've got various jurisdictional and corporate barriers in between to hide stuff. So the claimants are also saying this is a scam. Alternatively, they said that the other companies were agents of this one. If you're telling us that limited liability and separate personality treats the American entity as completely distinct the UK entity and we cannot get from one to the other, okay, we get that. But what we're saying is that the people in the US never did business with the American company. They were doing business with the American company as an agent of the British one. So if it's an agency issue, all liability between the ultimate victim, if you want, and the principal, which is the UK entity. So another argument they tried is that of agency. Alternatively, they said it is in the interest of justice not to allow this stuff to happen. It is improper, because what message are you really giving us here? The message that you're giving is that these are mechanisms that can be used to perpetrate abuses. That this is a message to corporations that if you guys want to do well by your shareholders and if you want to maximize the money, it's how you segregate the dangerous bits from the profit-making bits. This is how you shift the money around, and this is how you hide it. So all this comes to the court and gets debated at length, and we come to this outcome. Sorry guys, but this is how it works. The here says that there are ways that you can pierce the corporate veil. You can look at what the shareholders are doing in relation to this. In this case, the shareholder was the other entity. But just do this because it looks wrong. Simply consequence of respecting the system is some injustice. So the court is saying that this is a good outcome for the American people who answer. It's saying the outcome is unjust for them. However, if there is no impropriety in the way that the rules have been used, then there is no problem. So unfortunately, but a lot of stuff are unfortunate. So they didn't win. And that caused a bit of aggravation at the time. But what we do know now is that we have a list of specific cases in which the court will lift the corporate veil. These can be found either in case law or they can be found in statute. Some of the statutory ones are things that have to do with premature trading, for instance. If a company starts doing business before it is properly incorporated and they get the trading certificate, anything that happens up till that point is the direct responsibility of the people authorizing the action, which in this case means the directors. Wrongful trading is another statutory exemption, is that if a company is about to go bust and the directors know it's about to go bust, then their responsibility is no longer towards the shareholders, but it's towards the creditors. So they shouldn't do things that make it worse. This is a way around corporate barriers, but this is liability that attaches to the directors. The cases are about the stuff that I already mentioned. Whether somebody is acting as an agent of another corporate, when somebody's perpetrating fraud. You had a guy running everything. He was an airline pilot. He was the shareholder. He was the director of the company. He was employee. He was director. He was shareholder. He got killed in a plane crash. When they went to claim on the insurance said, no, we're not going to pay out because this guy, he was not properly insured, right? Because he was doing all these things at the same time. The court said, no. This guy had distinct roles within this. The airline company cannot kind of use the rules to kind of flip them around and then refuse to pay the guy. He was properly an employee. You got other cases. You got Guilford Motors. You got Jones and Lipman. These are fraudulent attempts to evade the rules. In Guilford Motors, you've got somebody who had transferred assets to a company. He was due to give back the assets himself, to be seized for him, transferred them to a company. So then they would say, oh, they're not mine, they belong to the company. The intent was fraudulent from the beginning, so this guy was not protected from limited liability. At Jones and Lipman, you got similar stuff. It's attempts to use corporate structures in order to evade existing obligations. This stuff's not allowed, it's fraud. If you manage to use some of those cases to prove that the intent is fraudulent, or that really there is joint decision making, so they're all doing this stuff together, then you lose then the distinction between parent and subsidiary and all the rest. Or if you can show that one company entity agent of the other, then you can go directly after the parent. The result of Adams and Cape is unfortunate. And it looks like it's condoning inappropriate behavior, if not fraud. It wasn't fraud, but it is definitely condoning appropriate behavior, because this split of the business activities was done precisely in order to avoid this type of liability. But it stayed. This came to be reinterpreted in cases like VTB and Prest. These are cases where the court comes again and looks at this thing. It doesn't fundamentally change the answer in Adams and Cape. So the English courts, in particular, they're very strict in applying the consequences of separate personality and limited liability. So this is good for you in a way, because it gives you the opportunity to discuss whether this is appropriate in terms of law, and also whether it is appropriate in terms of theory and principle or morality or whatever you want to call it, whether this evolution of the law is where we need to be.